Good morning. We're going to give everybody just a moment to get into the Zoom. All right, we're going to go ahead and get started. Good morning, and thank you for joining us on our webinar on equipping school boards for the new parental rights landscape. This webinar is being recorded and will be shared to webinar registrants and posted to the WIL YouTube page. If you have any questions, please use the Q&A function at any time during the presentation, and we will save time at the end to answer those Q&A questions. My name is Lauren Greuel. I am Associate Counsel here at the Wisconsin Institute for Law and Liberty, and joining me today is Education Counsel Cory Brewer, who leads our legal efforts in this area. For those of you who are just now hearing about WIL or our education work, I wanted to briefly tell you about who we are and what we do. So the Wisconsin Institute for Law and Liberty is a 501c3 nonprofit organization based in Milwaukee, Wisconsin, but we do nationwide work across the country on a whole host of different issues. Today, we will be talking mostly about education issues, which is why I also wanted to briefly introduce our Restoring American Education initiative by the Wisconsin Institute for Law and Liberty. We brought this initiative to close a critical gap by engaging parents, school board members, and teachers with an understanding of concerns and trends in education, while providing model school board policies and other resources to produce positive change at the local level. We have multiple buckets, and you can see them here on your screen. We have resources for school boards, resources for parents, resources for teachers, and we also have a school scorecard for Wisconsin citizens as well. And today we will be talking mostly about school boards and parents, as you can probably tell by the title. So we're going to be going through WIL's new Restoring American Education resource, the Parental Toolkit. And while the audience for this resource is primarily comprised of parents, the resource goes into laws of what laws are affecting parents and their rights and how they should use those rights at their child's school. There are two major areas that we're going to focus on today. First, Cory is going to cover what is the new law that school board members should be aware of, that we do cover in our resource, and that primarily comes from the Mahmoud versus Taylor case from earlier this summer. Next, I'm going to then briefly cover existing laws that we discuss in this resource to ensure that you as school board members are aware of these laws and how parental rights are implicated in them. Then, as I mentioned earlier, we'll have a Q&A at the end, so if you have any questions, use that Q&A function. Before I turn things over to Cory, I want to frame this conversation a little bit further. You might be thinking to yourself, what is this parental toolkit and why should I, as a school board member, care about it? And the answer to this is twofold. First, and as I've already touched on, the more parents know about their rights, the more likely they are to assert them. And we want you as school board members to be adequately equipped to handle requests, questions, and concerns when parents come to you. And second, and more importantly, students do better when parents and schools are collaboratively working together. It's often said that there isn't a silver bullet for improving student outcomes. However, parent engagement really is that silver bullet. Statistics have shown again and again that the most accurate predictor of a student's achievement is not income, it's not social status or class status, it's not racial demographic, but rather when parents become involved in their child's education at school, that is the best measure of student achievement. And that's really why we're all here today, because you as school board members care about student outcomes and want to collaboratively work with parents. So, with that, I'm going to turn it over to Cory to discuss what is new in the area of parental rights and how it affects school boards.
Okay, thank you, Lauren. Good morning, everyone. Thank you for joining us today, or if you're watching a webinar recording, thank you for tuning in. As Lauren mentioned, my name is Cory Brewer. I serve as Education Counsel at the Wisconsin Institute for Law and Liberty, or WIL. Today, I want to focus on one Supreme Court decision that directly affects your work as school board members, Mahmoud versus Taylor. This case changes how districts must handle parent opt-out requests, particularly when religious beliefs are involved. So today I want to give an overview and walk you through what the court said, why it matters for your school district, and what steps your board can take to ensure compliance with this new precedent, maintain trust with parents, and avoid potential legal challenges. And just before you go to the next slide, Lauren, if you can see on your screen here, this is a table of contents for our parental toolkit. So if there's anything I say today that we don't get to, or if you want to go back and see it, we have a Mahmoud versus Taylor explainer in the toolkit. And we also have a template opt-out form for parents. So that's all included in that same resource. So what did the court say in the Mahmoud case, and why does it matter to school boards? On June 27th, 2025, just a few months ago, the United States Supreme Court issued a landmark ruling in Mahmoud versus Taylor. In a 6-3 decision, the court held that a Maryland school district violated the free exercise clause of the First Amendment by refusing to allow parents to opt their children out of instructional materials and classroom instruction that conflicted with their religious beliefs. This case involved elementary school storybooks with LGBTQ themes. It also involved teacher training to silence any dissent to those pro-LGBTQ themes and to tell children who ask questions that they're being hateful and that there's only one way that children should think about this, regardless of their family's religion or values or how they were, how parents were discussing this issue at home and how they were raising their children. So initially in the case, parents had been allowed to opt out. The district was allowing that at first, but the district later revoked that option and said no opt-outs. And they also decided they were not going to provide any notice to parents or any alternative options for students in those classes. So parents wouldn't even know when this content was being taught. And again, this is very young, kindergarten, first grade, young elementary school children. And the Supreme Court ultimately ruled that that approach by the school district was unconstitutional. So the implication of this decision are significant. Public schools nationwide must respect religious opt-out requests whenever instructional content substantially interferes with parents' ability to raise their children according to their faith. The court emphasized that a standard called strict scrutiny applies. And I won't get too into the weeds here, but I want you as school board members, administrators to know that strict scrutiny means that schools must demonstrate a compelling interest and show that they are using the least restrictive means to override. If they want to override a parental opt-out request, that's what they need to show, a compelling interest, and they're using the least restrictive means to do so. And as we'll get into a little bit later, that's not a decision that individual teachers should really be making. So this is the highest standard of constitutional review, the most stringent standard used by courts to determine the constitutionality of government actions that involve rights such as those involving religion or parental rights. And Mahmoud involved both religion and parental rights. So the takeaway here is that simply claiming that honoring an opt-out would be inconvenient or disruptive, that's not sufficient. These requests must be honored, particularly when it involves family religious beliefs. And at the core of Mahmoud is the principle that parents have the primary right, they have this constitutional right to direct the religious upbringing of their children, even in public school. And as a result, boards should have clear policies for handling parental opt-outs. Will has developed a model policy on parent opt-outs that districts can adopt if they want to, or they can take a look at it and compare to what they have in place. Um, and doing so would ideally ensure that requests, these opt-out requests from parents, are handled fairly, they're handled consistently and efficiently in accordance with this new precedent. When a district receives a request, our belief is that the best practice is to provide a reasonable alternative for students and respond in a timely manner, work with the parents, collaborate, communicate. A clear opt-out policy protects the district legally. I think that's very, very important, is you want to have a policy in place just so that everyone's on the same page and they understand what the law is and they understand what your policies and procedures are to protect the district legally. It also clarifies expectations for teachers and it signals to parents. This goes to what Lauren was saying about that relationship. It signals to parents that their concerns are taken seriously. One of the most critical aspects of the Supreme Court's decision was the school district's failure to provide transparency. This was in Montgomery County, Maryland, and as I had mentioned earlier, the board not only denied opt-out requests, but it also decided it was not going to notify parents in advance about the controversial instructional materials. So attendance by these young children was mandatory, and parents had no ability at all to shield their children from content that conflicted with their religious beliefs. So this combination of not honoring opt-outs and not giving notice, that combination created a burden on parents' ability to guide their children's religious development. And we've given presentations on this topic in the past. This parental right to raise the upbringing of, to direct the upbringing and care of their child, this constitutional right, this is over 100 years old now. This is not a new right. It goes all the way back to a case called Pierce versus Society of Sisters from 1925. So that is a long established right that this case, this Mahmoud case, really reaffirmed. So for school boards, I think the lesson for school boards is clear. Providing parents with advance notice about controversial or sensitive material is absolutely a best practice. As I had mentioned earlier, a way to protect the district legally. And districts must always honor opt-out requests based on sincerely held religious beliefs, unless they can meet that highest constitutional standard that I discussed earlier. So notice and honoring opt-out requests are really kind of the takeaways from this case. I just want to dive a little bit more into the transparency, that notice issue that I mentioned. Obviously, very clearly from Mahmoud, we know about the religious opt-out request and the parents' right to direct the upbringing, including the religious upbringing of their child. Why do we need to give advance notice, or why should teachers, schools be telling parents about what kind of content, especially controversial content, is coming up in the classroom? So we believe that transparency is a matter of good governance, but it's really more than that. It also builds trust between schools and families. If you're at a school where that's in place, you know how true that is. And when parents know what's being taught, there's less potential for conflict, more opportunity for cooperation, and clear communication reassures parents that their voices are heard and respected, while also protecting the district from misunderstandings or legal challenges. And for school boards, transparency means ensuring that all families are treated consistently, providing advance notice of sensitive instruction, or ensuring that there's a policy in place so that your educators do that, and including opt-out procedures, ideally in handbooks, in a school policy, maybe on the district website. This approach really strengthens both the parental confidence and, we think, the school community as a whole. And this, I want to take my time going through this one because I think it's really, really important. Why is it important to train teachers and staff now that we have this Mahmoud decision? Having a strong policy is only effective if teachers and staff understand it and feel confident implementing it. Training of staff, of teachers, training is essential to help them recognize how to appropriately respond to opt-out requests. Sometimes a parent only submits an opt-out request to a classroom teacher. What should they do with it? How should they respond? Should they give it a copy to the principal to have on file? These are things to consider as you have a policy on this. And also a policy to ensure that parents are receiving that advance timely notice when a controversial or a sensitive issue will be taught in the classroom. As I had mentioned, the Mahmoud case involved LGBTQ content, storybooks being read to very young elementary school children. But I do not think that the notice requirement and honoring the opt-outs is limited to that content or to that topic, an area of content. If there are other things that a parent has sincerely held religious beliefs and instructing them in the school setting would substantially burden their right to raise their child according to their faith, those should be considered as well under this new standard, under this new precedent. So the training also clarifies that the ultimate responsibility for resolving any disputes, if there, for some reason, a teacher thinks, well, this doesn't seem like a sincerely held religious belief, or, oh, I don't really know if I need to honor this opt-out request. I don't think it should be the individual teacher making that decision. So the ultimate responsibility for resolving disputes should rest with the school board. Teachers, by the way, shouldn't be left to handle those types of difficult situations alone. It's another reason why we should have training, a policy, and someone that's the ultimate decision maker on those types of issues. So by providing this guidance, I think districts can prevent or at least significantly limit any mistakes like inadvertently denying a valid opt-out, mistakes like giving inconsistent information to families. This will help avoid all of that. And by the way, too, you're giving teachers clarity, you're giving teachers support, and you're helping them navigate this new legal requirement. So proper training, again, reinforces the board's leadership role, ensures a consistent approach, and empowers both staff and families. Now I have one more slide here that I want to just go through before turning it back over to Lauren. And again, I think I'm starting to see a few questions come in, but feel free to use that Q&A function if there's anything that comes to mind for you. Will is committed to helping school boards navigate this new legal landscape. You should be consulting and discussing it with your counsel for your district as well. But what Will has, and this is publicly available, it's free, it's on our website, is kind of a complete resource package designed to make compliance easy, simple, and practical. We have a legal explainer on the Mahmoud decision that is both available on our website as its own document and as part of the Parental Toolkit. We have a model school board policy. You can see it in the middle of your screen here. It's not called the Mahmoud policy. It's called Parental Opt-out Rights. And why adopt this policy? It kind of discusses the Mahmoud versus Taylor precedent. But that model policy is for school boards. It encourages how to work with parents, how to respond to opt-out requests, who makes that final decision. And we really drafted this in a way that's intended to give everybody just a clear roadmap of how these types of things will be handled so that you are in compliance with the law and working collaboratively with families. The last one is a template that teachers can use to communicate with parents. It's very basic, but I thought might as well just put something together, take out any question, tell, how can teachers tell parents we're going to discuss topic ABC on this date? Here's what it will essentially include. Let me know if you have any questions or would like to opt out. Something along those lines, just to keep parents on the same page. Like I said, all of these are freely available, will-law.org, schoolboardpolicies.org, and also for anyone who registered for this webinar, we're going to be sending links to each resource in an email after this presentation. So just to wrap up my part of the presentation, the United States Supreme Court set a clear standard, and the responsibility now falls to local school boards. And we think you can act with confidence, you can act with clarity and consistency. With updated policies, transparent communication, and staff training, your district can comply with this law, protect students and teachers, and maintain trust with families. So at this point, I'll transition back to Lauren, who will provide some guidance on other laws that your board should already know about and have policies in place for.
Awesome. Thank you so much, Cory, for going over Mahmoud today. And I just want to kind of preface this conversation with each of the things I'm about to go over are things that we could spend an entire webinar on, or at least an entire dedicated section like we did today with Mahmoud. But since Cory's gone over what's new, and Mahmoud is a newer law, that school boards should be aware of in terms of parental rights, I want to go over some of the existing rights that parents have that we've also highlighted in the parental toolkit. So, again, I want to talk about these rights, but they've been around for a long time. Your school likely already has policies and procedures to address some of these laws and some of these things. But in case you don't, or as a refresher so that you're not caught off guard by parent questions on these policies so that you can effectively engage with the parents in your school district, I want to cover 5 federal laws. And because these are federal laws, it doesn't matter what state you're in or where you're serving as a school board member, these laws will apply to you as well. So as you can see on your screen, there is a table of contents. You saw it earlier with the new Mahmoud resources and where that is. The things that have arrows now are things that already exist in law that I'm going to really quickly run through here. So first I wanted to talk about FERPA. You've probably heard the term FERPA before and maybe even know that it has to do with student privacy, but that's really only one aspect of this law. So FERPA stands for the Family Educational Rights and Privacy Act and is part of the United States Code. So this is a law that was passed by Congress. The very first thing that FERPA says is not that student privacy needs to be protected, which is in the law, but it's not the first thing, but rather that parents must be allowed access to review their child's educational records. So that's so important. It's so fundamental that it's the first part of this law. An educational record is a file, document, or other material that contains information directly relating to their student and is maintained by the school or person acting for the school, so like a teacher or an administrator. Once a parent requests this educational record under federal law, the school may not destroy that record. And additionally, when a parent requests to review an educational record, then the request has to be fulfilled by the school within 45 days. So this is all in federal law. This is different from any open records laws that your state may have. I know here in Wisconsin we have open records laws as well, but this is separate right that parents have. A school can, kind of like open records, charge a fee for copying the records, but it may not charge a location or retrieval fee for these records, nor may the school impose a copying fee that would effectively prevent a parent from exercising the right to inspect these educational records. So I wanted to spend a little time kind of diving into that first bullet point that you see on your screen here. I'm not going to do that for all three of these, or we would be here all day. But I really wanted to highlight that important piece, that important point that schools must allow parents to review their child's educational records. The other three provisions in this law you may be more familiar with. So, schools must notify parents of this law annually. Schools cannot disclose a student's educational records or personally identifiable information without parental consent. And finally, that directory information may be disclosed without parental consent if proper notice is given. So, if schools at the beginning of the school year let parents know that directory information will be made available to other families in the district and give parents an opportunity to opt out of that, participating in that directory information, you don't need to get individual consent from all the parents there. So that is a really quick overview of FERPA. And we dive a little bit more into all four of these aspects in our parental toolkit if you're interested in reading that legal overview there. The second one I wanted to cover was the Protection of Pupil Rights Amendment, or PPRA. And this is also a federal law that does two major things. First, it requires that parents be notified and given an opportunity to opt their student out of surveys on controversial topics. The law actually lists out what subjects included on the surveys would trigger that requirement. And I'm going to just quickly go through them here. That's political affiliations or beliefs of the student or the student's parent, mental or psychological problems of the student or the student's family, sexual behavior or attitudes, illegal, antisocial, self-incriminating, or demeaning behavior, critical appraisals of other individuals with whom respondents have a close family relationship, legally recognized privileged or analogous relationships, such as those of lawyers, physicians, and ministers, religious practices, affiliations, or beliefs of the student or the student's parent, or income other than required by law to determine, certain eligibility for certain programs. So those are the topics that if a school is going to administer a survey and any one of those topics is on that survey, they have to notify parents of that survey and give them an opportunity to opt their student out of that survey. The second part of this law is equally important, and it says that parents must be allowed to inspect all instructional materials being used in their child's education. Instructional materials means any instructional content that is provided to a student, including printed and representational materials, audiovisual materials, and materials in electronic formats. And similar to FERPA, I just want to highlight that this isn't something that is required or that parents need to follow an open records law to do. This is a right that they have under federal law, under the PPRA, to inspect the instructional materials that are being used on their student. Again, just a really high-level overview of this law, but I wanted to flag it. And again, if you're interested, we go into a little bit more detail in our legal explainer in this toolkit. Next, I wanted to talk about Title VI and Title IX. These are two laws that you have probably heard a lot about over this past year or so. As you can see here on your screen, Title VI says that no person in the United States shall, on the grounds of race, color, or national origin, be excluded from participation in or be denied the benefits of or be subjected to discrimination under any program or activity receiving federal financial assistance. So this law, in addition to Supreme Court precedent like the Students for Fair Admissions versus Harvard case, means that a school may not treat students differently based on their race in education. This is something that we found that a lot of schools struggle with, but probably not for the reason that you think. A lot of schools try to give certain students extra attention or help because of their racial demographic, not to harm these students or for malicious reasons, but rather because they think they're being benevolent. But it's important to know that it doesn't matter the reason behind the differential treatment. It is still illegal, even if it's for a purportedly good reason. Each student in your school district is an individual who should be treated as such rather than a member of a particular racial class, and that is what this law is designed to prevent. Title IX says that no person under the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any educational program or activity receiving federal financial assistance. I'm not going to get too deep in the weeds on this one because Will has some really great resources dedicated to Title IX specifically. But it's important to know that students cannot be denied educational opportunities or benefits because of their sex. And that's what this law is designed to prevent. So, the Office of Civil Rights, or OCR, under the Department of Education, is primarily who is responsible for looking into any allegations of Title VI or Title IX and determining whether or not they should open an investigation into the school district. And I want to highlight this because it's important to know that anybody can file a Title VI or a Title IX complaint against an educational entity like a school district. And OCR has actually recently created a portal for citizens to do just that. And you can see that portal on the left-hand side of your screen there. So it's really important for schools and school boards to know about these laws, what they are designed to prevent, and that people are submitting complaints against educational entities when they violate these laws, and that anybody can submit one of these complaints. The next thing I really quickly wanted to cover, and again, this is one of these topics that we could dedicate an entire webinar, if not a webinar series to, is the IDEA, or Individuals with Disabilities in Education Act. This is a law, a federal law that is in place, but it's important for schools to know that parents can be very involved in the IEP, Individualized Education Plan, creation process, as well as screenings and evaluations. You can see a list here of things that parents can do. They can request an evaluation, they can participate in these meetings, they can receive notice on school actions that are taken with regard to their child with disabilities and their IEP. They can also give or withhold consent for evaluations from the IDEA and for an IEP. They also have an ability to pursue a dispute resolution should the school and the parent not agree on a path forward for these students. And I wanted to highlight the IDEA today because we do include in our parental toolkit a resource that goes over the law just very high level and what parents are allowed to do and allowed to participate in when interacting with the school on an IEP or the IDEA. The last thing I wanted to highlight is the First Amendment. And obviously, this is something that we're all intimately familiar with. We deal with it on an everyday basis, and especially recently with some discussion about free speech and how this works on school campuses, what can and can't be said. But I just wanted to highlight, because these are two things that we highlight in our parental toolkit, that students have religious freedom rights in schools, and religious freedom is part of the First Amendment. And then parents also have free speech rights, which can be implicated most often in school board meetings or other meetings. But it's important for schools to know what the law and the case law surrounding these things are so that they can handle parent questions and student questions or concerns that come up on either of these issues. So for when it comes to students and their religious rights, they don't abandon their rights at the schoolhouse door. They're able to talk about their faith and share religious materials. They are able to ask for religious accommodations. They are able to opt out of lessons that conflict with their faith, and they're able to start and lead religious clubs and organizations at their school. They're even able to express their beliefs, their religious beliefs in their schoolwork. Those are all things that are protected by our United States Constitution and the Bill of Rights under the First Amendment, and then the subsequent case law that kind of fleshed out the details of that. And then when it comes to parental free speech, it's really important that school boards have a good understanding of free speech rights, especially when it comes to school board meetings, because a lot of school boards inadvertently or accidentally violate free speech rights at school board meetings all the time. So school boards cannot restrict speech solely because it's offensive. This is something that I know we're talking a lot about right now in our day-to-day life with everything that's going on in politics right now. But free speech means that parents have an opportunity and citizens have an opportunity to speak their mind. That's not to say that school boards can't have rules on decorum, but you can't ban a speech just because it's offensive and no other rules are implicated there. School boards can also not prohibit parents from criticizing school officials, particularly when it allows the praise of others. So, one of the things that we talk about a lot is viewpoint discrimination. You can't allow a bunch of parents to come in and talk about how wonderful a principal is, but not allow anybody to come in and express concerns about that same principal. You can't have one without the other. So that's kind of what that bullet point is. And then parents can raise concern about curricula and other school-related matters at school board meetings. And this is something we saw a lot during COVID and a lot surrounding library books in 2023. Parents are able to express their concerns at school board meetings, and school boards should be willing to listen to parent concerns at these meetings, as it really fosters this collaboration and this transparency. If parents feel like schools aren't listening to them, that's not a good avenue for a working relationship between a parent and a school district that we have shown will improve student outcomes. So I know I kind of fire hosed you at the end there, but I did want to leave some time for some questions, for some Q&A. So I'm going to turn it back over to Cory to facilitate some of those questions.
Yes, the first thing I'm going to do, and I apologize if I already answered one of your questions in writing, but I'm just going to go through a few of those because they were really, really great questions. Oh, I suppose I can turn my camera back on. Sorry. There were some really good questions, and I think it's worthwhile for anyone who's not following along in the chat to hear what the questions and answers were. Keep including your questions. We'll do our best to get through. We have quite a bit of time here before the hour, so we'll get through some of these questions. Many are related to the Mahmoud decision. I do see a message here, someone from Montgomery County, Maryland, and they said it's more than just the books. There are lesson plans that aren't privy to parents. So, I mean, that specifically the issue of the lesson plan was not an issue in the case, but I think that goes towards there's the issue of transparency and that partnership with parents and creating that trust so that parents know what their kids are going to be exposed to in the classroom. I'm going to go through just a few questions here. If you go to the answered questions, there's a link to the toolkit. And again, we'll be sending that out after this in an email. So this question is something that comes up a lot. Nancy wants to know, you said particularly when religious beliefs are involved. I did say that. Good catch. She says, I'm concerned that religious exemptions might be the only avenue for opting out. Sometimes lawyers don't want to represent clients who have non-religious reasons for opting out. How broadly can Mahmoud be interpreted? So that's kind of the million-dollar question, but I'll let you know what our analysis is. So the Mahmoud versus Taylor decision, as I mentioned, was a First Amendment free exercise of religion case. So it does directly apply to situations where parents request an opt-out based on their religious beliefs. Schools are required to honor those requests. But that said, Mahmoud is part of a broader line of cases recognizing that parents have fundamental constitutional rights, not just in the religious sphere, but in directing the upbringing and education of their children more generally. So this is tricky, but while Mahmoud itself doesn't mandate schools to honor non-religious opt-out requests, first of all, check your district policies because you might have something on this already, like a controversial issues policy. But also, the logic of Mahmoud, the logic of that decision could point towards the possibility in the future of a similarly recognized or reaffirmed right of parents to opt out for non-religious reasons. So not totally clear on that one, but hopefully that's helpful. Lauren, I'll let you keep making your way through some of these other questions. If there's anything you want to tackle, just let me know, but I'm going to move on to the next one. This is another really great question from Kelly. What do you recommend for how to handle supplemental materials? For example, videos, activities, resources. Sometimes teachers add these to the approved curriculum. And I know from speaking with a lot of teachers and former educators in our network that sometimes teachers add these the day before or a few days before. It's not like it's planned at the beginning of the unit or the beginning of the semester. What do you do with that content? It happens quite a lot. And those materials tend to cause the most problems. Sometimes they're not always approved by the board, or sometimes not even run past administrators or the building principal. And what happens then if a parent has a problem with that type of kind of like, quote, supplemental content? So here's my thought on this. Under federal law, and Lauren went over this about what is considered instructional materials, supplemental materials are still instructional materials. So the same rules do apply as with the adopted curriculum when we're thinking about Mahmoud and opt-out rights. So in light of that decision, if a parent objects to supplemental content on religious grounds, the school must honor that request. And if a teacher, just consider this scenario with me. If a teacher uses controversial materials in a supplemental sense without providing advance notice, maybe something that the teacher decided to include the day before, the teacher or the school, since the teacher is a public official in a public school, could be violating parents' rights under that Mahmoud framework. So I think two things. School districts should have clear policies that you do, of course, want to balance teacher professionalism, some teacher autonomy, and balance that with some oversight. So maybe require, if there's going to be a controversial topic added, have the teacher run it past the administration first, and maybe both, give parents notice first if it's controversial. If a teacher isn't sure whether something is controversial, they should err on the side of transparency in providing that notice. So I think this approach would be good because it reduces the legal risk, provides transparency, and again, builds that trust with families, and it gives teachers clarity on their expectations.
I will let you do the last Mahmoud question, Cory, and then I'll switch over to a different topic that we got a question on.
Okay, this is another really good one. It's something that we considered when we were drafting our model policy. Tom wants to know, what is the standard for determining what topics require parental notice? How do you know when to give prior notice to parents, and what types of things should you allow opt-outs for? So what the court said was content that, and again, that case involved LGBTQ storybooks, but the court described content that, quote, substantially interferes with the religious development of children and imposes a burden on religious exercise, citing a former case. Okay, so that provides some clarity, but schools won't always know what content is going to interfere with the religious development of children, what content is going to impose that religious burden, and it could be different for each family depending on what their religion is and what their beliefs are. And while districts, I think this is important too, while districts can consider the sincerity of those beliefs, districts should not be asking parents to prove that they are right, that, hey, my religion is, okay, I'll give an example. I'm Catholic. I believe that God created male and female, and that for that reason, I don't want my child to be learning that there are more than two genders, or I don't want my young child to be learning about transgender ideology in the classroom. The schools should not be coming back and saying, oh, cite, where is that in the Bible? Where is that in the catechism? Prove that that's what the Catholic faith teaches. That would be inappropriate, but you can consider the sincerity of the opt-out request. So, slight tangent there. Told you what the court said. You don't want to interfere with religious development of the children or impose a burden on religious exercise. So what should you do with that information? I think districts want a policy. You definitely want a policy to clarify this. Work with your legal counsel on exactly what it might say. But we have an example in our model policy. We actually decided our approach was to include a section on instruction commonly subject to opt-outs. So there's a few different bullet points to give teachers uh, something to keep in mind about, okay, if I'm teaching about this content, maybe I want to provide notice and let parents know that they can opt out. And at the end of it, it includes controversial issues generally, which our policy defines as anything that's the subject of intense public argument, disagreement, or disapproval. This includes issues which may have political, social, or personal impacts on students or the community. And it includes issues that are likely to arouse both support and opposition in the community. So I think the key there is you want a policy and you want everybody on the same page.
Awesome. We got a question about school board meetings. Can parents criticize school officials at the school board meeting? This is, I'm going to give you a little bit of a legal answer. I know everybody hates it when we say this as lawyers, but it depends, probably, but it depends. Here in Wisconsin, at least, school boards can choose whether or not they want uh, parent participation in school board meetings. We believe strongly that this is best practice. It gives parents an opportunity to discuss concerns that they may have and participate in the school community, which is really the whole theme of this presentation, is keeping parents involved because it is really, really good for students and student outcomes. So we don't think that schools should get rid of this open commentary period, but technically under Wisconsin law, they can. And if that's the case in your school district that no commentary is allowed, then no, parents can't criticize school board or school officials at a school board meeting. However, if a school does allow public commentary and they are allowing parents or community members to praise school officials at school board meetings, get up and say, kind of like the example I gave, like, I love my principal at this elementary school, she is phenomenal, and I just want to commend her in front of the school board. If they're allowed to do that, then they have to be allowed to get up and say, I'm really frustrated with this principal, and here's why. Um, because if you're going to provide one viewpoint, which would be the praise of that school board official, then you have to allow the counterpoint. Otherwise, you're getting into viewpoint discrimination, which is unconstitutional under the First Amendment. So my short answer is probably it depends, because it does depend on the policies of your local school district. So you just have to make sure that you take a look at those policies, and know, is public commentary even allowed in your school district?
I can answer, by the way, I just added, and again, we'll email this, but I just added a link to the parent opt-out right model school board policy that Will created. I put that in the chat if anyone wants to follow along with me or open that up right now. But we got a question that says, okay, so teachers are not the ones that set the policy. They're not the ones that are the ultimate decision makers. So where do the administrators fit in? Does it go right to the school board? That's kind of up to you. You can decide exactly how you want to handle those opt-out requests. I would stress that you want to make sure, talk to your district legal counsel to make sure that it's in compliance with the new decision. And you want a policy so that it's very clear. The way Will wrote it in our model policy is it would go directly to the school board. We have indicated that if there's any staff in the district, a teacher, a principal, who thinks there could be a legal basis to deny opt-out request based on a religious reason, if anyone thinks there's a reason to deny the opt-out and not honor it, that should be referred to the school board to determine. And then we have a whole section on just review and response. What exactly does that look like? What's the timeline? What happens in the meantime before that decision is made? And I think what should happen in the meantime is it's honored in the meantime, because it's a big deal. Again, it's that strict scrutiny standard, and you're dealing with constitutional rights here. So that's our recommendation, is that no opt-out request should be denied without formal action by the school board. But that would be something that I think you can craft your own policy, work with your legal counsel. You just want to make sure that you're respecting parents' rights, following this precedent, and have something that works for your district.
Cory already touched a little bit on this question, but I did want to address it as well, because there's a separate question on it. But when a school has concerns about what is being taught in the classroom, primarily when it comes to day of decisions or supplemental materials, how, as a school board, do they handle these teachers, and know, what's being included in the classroom? And I think the point we talked about for quite a while today was some of these trainings. If a teacher is going to choose to discuss certain materials in the classroom, controversial materials, and they're not letting the school board know, they're not letting parents know, and it's one of those topics that's sure to cause issues, they're putting the school at legal risk. It's possible that a parent then could bring a complaint against the school district for not receiving an opportunity to opt their student out of certain materials. So that's something that we wanted to emphasize during this presentation, that it is really important in light of Mahmoud and the decision over the summer to ensure that teachers are aware of this new law and how that they should handle it. Doing teacher trainings, having a model policy, these are all things that are, or having a school board policy, these are all things that are very important in ensuring that the school is working together as a whole, and being consistent and working with parents and protecting their constitutional rights.
I do want to note too, I just want to, you might be thinking as a school board member or administrator, oh my goodness, like how are we going to comply with this? This sounds like a lot. This could be an administrative burden. What if we have a lot of parents opting out? And first of all, I want to encourage you, you can do this. We want you to be confident, have clarity, collaborate with parents. It is workable. You can do this. And I think it's good governance to do as well. But I also want to note that that was an argument that the school board or the school district in Montgomery County made to the United States Supreme Court, that it's creating too much of an administrative burden. We have too many parents opting out. For those of you who aren't familiar with how the case came to be, you had parents of all different religious backgrounds, Jewish, Catholic, Muslim, Christian, and they all came together and said, we want notice, we want a chance to opt out, we don't like that we're not involved. And so many of them were opting out that the school said, this is too much of an administrative burden. How are we supposed to do this? And I just want to say that the United States Supreme Court did not buy that argument. An administrative burden is not a reason to violate parental rights or violate First Amendment rights. So I understand it might be a change. Hopefully it's not too much of a change. But again, transparency, working with parents, having a policy in place. And I believe that that you all will go back to your local communities and handle this really well.
All right. Well, we covered a lot of ground today. This parental toolkit also covers a lot of ground. It's over 70 pages long. So if you want to deep dive into any of the topics that were covered today and some ones that we didn't get to, please feel free to check out our parental toolkit. It is targeted at parents, but it still gives really great legal overviews of all of the issues that were discussed here today, and can serve as really good reminders for school board members who are serving in their community. If you think of anything after this presentation that you want to ask us, Cory and my emails are on the screen. Thank you so much for being so participatory today and having your great questions. And Will is here as a resource for you. So please feel free to reach out if you have any additional questions. And with that, I think we will give you 4 minutes back of your morning. Have a great rest of your Tuesday.
Thanks, everyone.